A lot of people ask me, what's the difference between a will and a trust? Why would you choose one over the other? And more importantly, do you even need a will or a trust? Well, you need to choose carefully. Because the thing is, if you choose the wrong estate plan or you screw it up, the chances are that it might almost have been better that you had no estate plan at all and you let the court handle your situation. Hi, my name's Matt Tram and I've been a Minnesota attorney for 12 years. And we're gonna talk today about the differences between a will and a trust. Let's get into the first question. So what is a will? Well, a will is something that we draft and we put down instructions, usually where should we leave our assets to, our children or other beneficiaries. And a lot of people mistakenly think that when they put this document together, they might even have an attorney do it for them. That attorney gets witnesses and notarizes that document. They have a legally binding will. But when people do that, they mistakenly think that that has somehow allowed them to avoid probate. And this leads into our next question, which is, what is a trust? A trust might have a lot of the same language in it. Where do you want your assets to go? To your children equally, to your children in some charity, whatever it is. A trust allows you to, again, put down your distribution language and desires. However, a trust is set up differently. It does not require the input of the probate court in order for those instructions to be administered. So what are the differences between a will and a trust? Well, as you can see, a will has instructions, a trust has instructions, but the will requires the probate court in order for those instructions in that will to be administered, while a trust can stand on its own and be administered by something called a successor trustee that you name when you pass away, without the need to involve the court. So why would you choose a will? Well, a will is going to be a viable option for certain people that have very simple assets and very simple family situations. Let's say you had one child and very limited assets, and we can use beneficiary designations to transfer all of your assets to that one child. While assuming that you're not worried about protecting that child from their own lawsuits, divorces, or financial issues, a will might be a viable option as a plan, as a backup to those beneficiary designations, still allowing you to understand that you would avoid probate. Again, if we do the will, we're not planning to use it in that case, because the will have to go through probate. So in this case, the will would only be there as a backup plan. So this is obviously a segue to why would someone choose a trust? Well, in this case, maybe you have a more complex asset situation. Maybe you have a more complex family situation. Maybe you have something that you actually want to happen after you pass away, other than just a transfer of the assets. Maybe you've got a child that's a special needs beneficiary. Maybe you've got a child that might hurt themselves if they get all the money with gambling or drugs or otherwise. Well, in this case, a trust is going to be able to allow you to draft around those problems and still avoid probate. Another good reason to use a trust might be that you just have 3 kids and you're concerned about them having to act together in relation to, let's say, your property when you pass away, your house. Should they all become owners of the home jointly through a beneficiary designation called a transfer on death deed? A lot of times this does prompt them to fight with each other. A trust can solve those problems. The next question is, why do you need to be so careful when setting up your estate planning documents? And I do think back to a famous celebrity, and I'm not going to get into who it was, but she had actually drafted wills and she had actually done them in her own hand. She had done several of these, and after she passed away, her beneficiaries found these wills and they all claimed that the one that favored them was the valid will. And in this case, millions of dollars were spent in litigating this issue. And in this case, it probably would have been better that she hadn't even done any will at all, because the court would simply have split her assets equally between her rightful heirs, albeit through a very long and drawn out process. But of course, there wouldn't have been a basis or as much basis to challenge what actually ended up happening. So why do you need to get to this sooner rather than later? Well, I always tell my clients it is so much better to come in and do this planning while you are still vertical rather than laying horizontally, whether you've experienced an accident or an illness or you've actually passed away. If you passed away, it is too late. Even if you're sick, I've been a part of many of those situations, and it is very unfortunate when someone is on their deathbed to have to be thinking about these types of issues when really you should be preparing yourself and spending your time with your family that you do have left. And so very important to not leave this till the end and to do it in a calm and collected manner ahead of time. So I hope you enjoyed this video, and if you live in Minnesota and want to make sure to protect your family and assets from all of the threats we just talked about with the very best estate plan, click the link below and watch our free video about how to protect your assets and family with a solid estate plan in Minnesota.